The only people who don't want to disclose the truth are people with something to hide.
At you. This is Full Contact with Eric Rush Live here on a Labor Day, and we are here with D.C. Attorney Montgomery Blair Sibley, who has had been involved in some interesting cases regarding President Obama's eligibility. Right now we are discussing the case of Elizabeth Ann Duke, a fugitive domestic terrorist. The Obama administration dismissed an indictment against her. She has been on the lam since 1985. This is obviously rather bizarre. And, well, I'm not an attorney, so I won't start throwing the illegal word around, but back with Montgomery Sibley. Are you there, sir?
Yes, I am, Eric. Yes, I am. As you know, we left off with me pointing out that the order Magistrate Judge Robinson signed made representations as to what transpired, which were completely false. That is, there was no cause or reason shown for dismissing an indictment.
Right. That is important.
So, that's point number one that's very important. So what I did next is go back to the judge and file a motion asking her to let me intervene in the case and make an argument to her that she needs to vacate her order dismissing the indictment, and that I'd like to proffer some other information to her as well. Now, I need to back up for a moment to this question of a magistrate judge versus a district judge and go back to Civics 101.
Right.
As we know, our Constitution divides power among three branches of government. One, of course, is the executive branch, the president. Second, of course, is Congress. And the third, of course, is the judiciary. And so we have what are known as Article 3 judges. These are federal judges. They're appointed for life, and they have unlimited power under the federal system. Congress wanted to put more judges on the bench to handle the workload without giving those new judges unlimited life tenure and full Article 3 powers and, of course, a full judicial salary. So they created congressional judges, which we call Article 1 judges, and they named them magistrate judges. They serve for 5 years. They can be kicked off the bench at any time. And they handle the more routine matters that don't require an actual decision that decides the case finally. In fact, they're prohibited from finally deciding a case. They only make recommendations to a district court, Article 3 judge, of how to dispose of a case. So I went back to Magistrate Judge Robinson and said, wait a minute, you misrepresented what transpired. Here's the transcript. But more importantly, you're not even legally authorized to dismiss an indictment. And you need to vacate what you've done, and you need to be heard because I've got something I want to tell you. Well, of course, she immediately entered an order telling me to get lost and that she wouldn't even file my pleading of record because she didn't want anybody to see what I was saying. So she sealed my pleading so no one could read it publicly and then said no, she wouldn't do anything about it. Well, that was a dead end with the Article 1 Magistrate Judge Robinson. So then I went to the 13 Article 3 federal district court judges in the District of Columbia Circuit here in Washington, D.C. And I wrote them all a letter and said basically the same thing. Magistrate Judge Robinson misrepresented the record. And secondly, she doesn't have authority to dismiss an indictment anyway. What are you going to do about it? Well, as usual, we're allowed to petition the government, but the Supreme Court has held that they don't have to listen or respond.
Right.
So our Article 1 right to petition is kind of toothless, if you will. But the end result, Eric, and I know we've only got limited time, is they failed to respond. Not a single one of those 13 judges answered my letter to them saying, you have a subordinate judge who's violating the law. What are you going to do about it? Okay. Well, there's only one place to go at that point in time, and that is to the U.S. Supreme Court. So I organized what's called a petition for certiorari, and the Supreme Court is not an appellate court. That is, when you are convicted of a crime or you have a civil judgment against you, you have an automatic right to appeal to an intermediate appellate court. You can go to the Circuit Court of Appeal in the federal courts. If you're in New York, you go to the Court of Appeals Appeals, and so forth and so on. But the Supreme Court of the United States is not an appellate court that anybody has the right to walk into. It's only by discretion that the court takes cases, and they get 8,000 cases filed a year. They take about 80, which is about 1% of the petitions that are filed there they actually decide. That's a topic for another show, Eric. So I went to the Supreme Court, and I filed my 40 copies of my petition for certiorari, saying you have an obligation to supervise the lower courts. Here's an instance of grotesque misconduct by a judge. And I added another factor that I hadn't really been publicizing before. When Magistrate Judge Robinson signed the order in 2009 dismissing the indictment against Elizabeth Ann Duke, she didn't sign it as a magistrate judge. She put her written signature over a title of United States District Court judge. That is a felony. It is a felony to impersonate a federal officer, and she impersonated a federal officer in an order which dismissed an indictment which she wasn't authorized to do, and which she misrepresented the reasons for, which there were none, in her order dismissing the indictment. So I sent that in, and I walked down to the Supreme Court. You have to file at the guard shack behind the Supreme Court, because you're not allowed to walk in the Supreme Court for security purposes anymore with paper. And it's always amusing, Eric, when you get the security guard to come out, they come out and they give you a garbage bag, and you put your 40 copies of your petition, your pleading, in a garbage bag, and then they seal up the garbage bag and take it away to wherever they process, those pleadings.
That's some high-tech procedure there.
It's high-tech. And I always get a kick, and I've been there 40 or 50 times, and it's always hilarious to me that I start out by putting all my hard-earned, legal work in garbage bags.
Yeah.
So just to wind up real quickly, the end result was the court got my pleading and immediately sent it back to me and said, no, the judges aren't authorized to see this. You have an appeal from the highest court of appeal that you could have. And so now we're in this position where I wrote him back again, and I said, no, this is not an appeal to the Supreme Court's discretionary jurisdiction.
Okay.
This involves the conduct of judge and judicial officials, and therefore the Supreme Court has jurisdiction. So that's the story as it is today. Wait and see whether the clerk will let me file my pleadings with the Supreme Court.
Okay. We're coming up on a break. Let's hold that thought, and we'll get back with it right after, on the other side of the break. Full Contact with Eric Rush Live, talking with Montgomery Sibley.
The only people who don't want to disclose the truth are people with something to hide.